All right, y'all, man. So we back with that video, but I uploaded like 27 different pages into ChatGPT from the trial transcript, and just pretty much, like I said, from Stephen Adler Vincent, what he testified, and anything that kind of talked about DNA. That's what I type. I put in. I put anything that kind of referenced the DNA. I found those, and that's what I uploaded into ChatGPT. So we're gonna get started. We're gonna get started like this. So the first one I uploaded, what was that? 10 pages, right? So let's get into it. Says Jonathan, this right here is exactly the kind of record that can move a case back into a court if it's handled correctly. Mind you, I try to keep them in order because it's a bunch of pages that I had uploaded, and I try to keep them in order as I uploaded them. I just couldn't upload all 27 at one time. And it says, I've gone through what you just uploaded and let me explain plainly what just happened at your trial, because this is bigger than it looks. Stick with me. Just stick with me, y'all. It says the detective testified without seeing the DNA reports on page 40. Told you I uploaded this shit. So it says, question. This is from trial. You didn't see the May 14th, 2015 report. That's what the prosecutor asked the detective. Answer, no ma'am. Question, you didn't see the April 17th, 2015 report. Answer, no ma'am. Question, you didn't see the February 13th, 2015 report. Answer, no. Question, and you didn't see the May 27th, 2014 report. No. That means a law enforcement witness took the stand in front of the jury to talk about DNA evidence without ever reviewing the lab reports. That is due process, false impression issue. Hold on. That is due process / false impression issue. Because now the jury is hearing interpretations of forensic evidence from someone who I didn't even know how to read these lab reports. That is in your records. So that's what she said. That's what the detective said. She didn't even know how to read the lab reports, but she was up there testifying about DNA. Like I said, you don't know this stuff sitting there and you're going through trials. That shit is like speeding through. You know what I mean? This is shit you obviously catch on the back end. And it says, the jury was told there was DNA in the crotch of the panties on page 38. Question, were you aware that there was a mixture of two persons' DNA in the crotch of her panties? Answer, yes. Then, question, and were you aware that the DNA test excluded Jonathan as a contributor to that mixture? Immediately, the prosecutor objections. Ms. Freeman, I object to the characterization of the evidence. That's not what the reports say. Now pause. Your appellant records already says male DNA was present. It was tested with YSTR. You were affirmatively excluded from being a contributor. No other suspects was compared. So the jurors here, there is DNA, but defense tries to say he's excluded. Prosecutor objects, saying that's not what the report says. That creates a misleading evidentiary dispute in front of the jury about what the science actually concluded. That's what I'm saying, dog. Like, it's a bunch of contradiction, fool. Like, it's crazy. It's just crazy. It says 3. Defense counsel says no objection to the DNA reports. On page 147, Mrs. Rekoff, judge, I have no objection to state's exhibit 245 and 264. The court, they are admitted. Those are May 27, 2014 reports, April 17, 2015 reports. So, no objection to admission, no limiting instructions requested, no request to publish the exclusion clearly, no motion to clarify the mixture interpretation. If those reports contained your exclusion from male DNA in the crotch area, and counsel allowed them in without highlighting that fact, that becomes Strickland deficient performance, ICA. Now combine this with the DNA reinterpretation you already have in the appellant records. Upon reinterpretation of the previously gathered data, DPS issued a subsequent report. That is Article 11.073, Change Scientific Understanding. Courts grants relief where same biological samples, same testing, but later interpretation changed under new thresholds guidelines, which is exactly what DPS admitted happened. The legal claim that are now emerging from your own trial records, you are potentially looking at ineffective assistance of counsel, failure to emphasize exclusion from predator's own male DNA, objection to misleading characterization, request clarity on mixture interpretations, present exclusion in closing in a meaningful way, due process, false/misleading impression. Jury heard the DNA evidence discussed by a detective who admitted it was she. He said he, but it was a she. She never reviewed the lab reports and didn't know how to read them. That can fall under Napier/Giglio, whatever his name is, type misleading evidence principles, even without perjury. Then it says 3, Article 11.07, junk/evolving science. DPS reinterpreted the same the same data on the new interpretation guidelines and issued a later report. That is textbook 11.073 territory. It's a lot, bro. I'm just reading to y'all. Y'all can make this shit make sense. Then it says 4, actual innocence evidence. Unknown male DNA found in crotch of victim panties. It says victim reported no sexual contact the week prior. You excluded as contributor. No other suspect compared. Y'all, it's a lot, bro. Oh no, man, it's a lot. Then it says next move. You now need to mark the exact page where exclusion was disputed. Reports admitted without objection. Detective admitted not reviewing reports because those become records. Those become record-based Strickland claims, record-based due process claims, science-based 11.073 claims. This is how you get back in front of the judge through an 11.07 writ. On to part 2.